Yes, I have sort of a group of questions. The Civil Rights Act of 1875 was undermined completely, and probably by the Supreme Court itself. It seems to me that Supreme Court action over the years, Dred Scott, Plessy Ferguson, the Civil Rights Act, and all the Jim Crow laws that they allowed, plus also making it possible for one state to stop down any black voting. I think these are some of the most despicable acts in our history, and they are Supreme Court initiated. Can you talk about that, please?
Barack Obama?
Well, this is, I think, one of the points that I was making earlier. And it connects actually to your original, the other caller's question about could we do things differently. Obviously, this kind of debate is always difficult. People always say, you can't judge the actions of a judiciary or the framers looking, 200 years back. I think what is certainly true is that at each juncture in American history, there is room for different decisions being made. Perhaps not decisions all the way to our liking, but there are better and worse decisions. There are decisions that expand freedom or lessen freedom, decisions that solve some of our contradictions or exacerbate contradictions. In that sense, I think it's legitimate to say something like Dred Scott is a disastrous decision that is not compelled by the facts before the court at that time. That Plessy versus Ferguson is a fundamentally dishonest decision even by the terms of the courts at that time. I mean, let me just give you a very quick example. In Dred Scott, the Chief Justice of the Supreme Court had gone to great lengths to document why it was that segregation was an indication that blacks had no rights that whites were bound to respect, and that blacks had never been considered part of the populace, the citizenry that we should consider. Only a handful of years later, right? I mean, we're literally talking about the next big case is Plessy versus Ferguson, where the court goes out of its way to say, why are blacks being offended because we're segregating people in train cars? They must be paranoid. There's no reason to take offense at that. Nobody means anything by that. We're just trying to keep the peace. Well, when you look at a case like that, you have to say that the judges in Plessy are being dishonest because they are obviously familiar with the Dred Scott opinion. They know exactly what the Supreme Court holding was in that case, and yet they choose to pretend that case never existed. And I think that one of the ways that we can judge history is to see at those junctures, A, are people being honest, and B, are they trying to do what they can given the constraints that they're operating in, and very real constraints. I don't think that the judiciary prior to the Civil War could have freed the slaves through the courts. That's not possible.
But in fact, though, we're talking about counterfactuals,
right,
and the tendency is to talk about counterfactuals where the outcome would have been better.
Right. It could have been worse.
In fact, that's what Abraham Lincoln feared. He feared that the Supreme Court was about to make a ruling that Southerners could live with their slaves in the free states, 1857-58. We're going to nationalize slavery. The administration newspaper, the Washington Union, said that the abolition of slavery in the North was an illegal attack on private property.
Right.
Things could have been worse. The Southern slave masters had extraordinary power in the antebellum period, and that's a fundamental fact.
I think that's absolutely right. Let me just make one more point off the caller, though, and that is that the judiciary does not become generally a force for liberation or the explication of a moral view of this issue until much later.
Hi, I have a couple of quick related questions. First, I just wonder if your panelists, particularly Richard John, are being sort of easy on the framers and calling them men of goodwill, and that
some men of goodwill.
Some of them even, and that might the Constitution have been a very conservative moment and an attempt to squash the potentially radical implications of the Declaration of Independence.
With regard to slavery, or even more generally?
With regard to slavery in particular, but more generally, and then this is related to another question, I was wondering how, particularly Jan Lewis, how you think about the way that freedom made its way into the Constitution based on the definition of slavery. So was Jefferson's sense of a free citizenry inextricably bound in some way to a sense that there were also dependent citizens.
Richard, John?
Yeah, I mean, this is a classic question. Is the Constitution a fulfillment of the principles of the Declaration of Independence? Is it a repudiation of the principles of the Declaration of Independence? The Declaration of Independence, the principles of it, the values, were important to the founders, but the document itself was not. It was not much debated in the Constitutional Convention. The founders were dealing with a set of practical problems. Among those had to do with the settlement of Western lands, how that was going to be administered, and the Northwest Ordinance was a great triumph for opponents of slavery. So unless you believe that government is sort of intrinsically is intrinsically unable to solve problems, it seems to me hard to believe that the Constitution was a repudiation of the principles of the Declaration of Independence. And in fact, how were the slaves freed? They were freed in the course of a long and bloody war by the Union Army. And then how was their freedom ratified? It was ratified by a federal constitutional amendment. So I think it's easy to be very hard on the founders and to be very hard on our governing institutions. But I just wish we'd think about what the alternatives were, what the practical alternatives, and not some possible counterfactual dreams we might have.
Barack Obama, what are your thoughts on the Declaration and Constitution?
You know, I think it's a remarkable document. I think
which one?
The original Constitution, as well as the Civil War amendments. But I think it is an imperfect document, and I think it is a document that reflects some deep flaws in American culture, the colonial culture nascent at that time. African Americans were not. First of all, they weren't African Americans. The Africans at the time were not considered as part of the polity that was of concern to the framers. I think that, as Richard said, it was a nagging problem in the same way that these days we might think of environmental issues or some other problem where you have to balance cost benefits, as opposed to seeing it as a moral problem involving persons of moral worth. And in that sense, I think we can say that the Constitution reflected a enormous blind spot in this culture that carries on until this day, and that the framers had that same blind spot. I don't think the two views are contradictory. To say that it was a remarkable political document that paved the way for where we are now, and to say that it also reflected the fundamental flaw of this country that continues to this day.
All right, let's take one more call. 312-832-3124. Let's talk with Ted. Good morning, Ted. You're on Odyssey.
Hi. My question is to the panel to talk a little bit about the 3/5 compromise, because it strikes me that while in today's world we look at that as kind of an obnoxious result, saying that a human being is less than a human being, it always struck me that compromise was really for the benefit of the non-slaveholding states, that they didn't want to give the slaveholding states the kind of super representation they would have if all the slaves were counted in the population.
Barack Obama?
Well, I guess you could say that they could have said, we're going to count everybody equally. The other way of saying it is that they actually did get a super representation. I mean, the average white Southerner had significantly more representation in the federal government than the average white Northerner, because these slaves were counted despite them not having a vote. That disproportionate Southern power in the federal government continued through Jim Crow. Essentially, when African Americans were disenfranchised, that's part of the reason why you have people like Sam Rayburn and Lyndon Johnson and all the enormously powerful Southern congressmen. A part of its longevity, but part of it is that Southern whites are overrepresented and their power is unchallenged and undiminished at the federal level. I guess you could say that the North might have ceded even more power to the South. I'm not sure that it reflects actually a good deal for the northern states. Although, as Jan said, I do think that the 3/5 clause implicitly, at least, points in the direction of saying that we need to be counting each individual, and that lays the groundwork for the one person, one vote later on.